Hi, everyone. So, my name is Sarah, and I'm an organizer with Justicia with migrant workers. And we have two guest speakers today, Jessica and Malika, and they'll be talking to us about detention reviews. But before I give them the podium to speak, I'll just start with the land acknowledgement. So, Toronto is in the dish with one spoon territory. The dish with one spoon territory is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. And with that, I'll just give you guys the podium to speak.
Hi, everyone. So my name's Jessica. I'm an immigration lawyer. And what we've done for this presentation is we've divided up some questions that we think you might all have. And so I'll go first. So first, what is immigration detention? Immigration detention is supposed to be administrative, meaning it's supposed to ensure the efficient application of the immigration system. It's not supposed to be punitive. However, in reality, being arrested by an immigration officer is often described as a terrifying experience. Getting released from immigration detention can be very difficult. Being in immigration detention often triggers deportation proceedings, and it most certainly does feel like a punishment for not being a Canadian citizen. So who can be detained? In terms of who can be detained, anyone who's not a Canadian citizen can be held in immigration detention. That includes refugees, refugee claimants, foreign workers, and permanent residents of Canada. A lot of folks, especially who are permanent residents, don't realize that this can happen to them. And so where can you be detained? I'm sure many folks have seen images of detention centers, immigration detention centers in the US. Immigration detention in Canada is a bit different. In Ontario, there is one detention center that is specifically for immigration detention. It's called the Immigration Holding Center. The rest of immigration detainees are detained in jails throughout the province.
Hi, everyone. My name is Maleeka Mohammed. I'm an immigration refugee lawyer as well. The next question that we thought would be of relevance is, why can they detain you? So once you've been arrested, what are the reasons that they can keep you in immigration detention? So there's a few grounds that they can argue that exist in your case. So the first one is if you're a flight risk in their view. This is also known as unlikely to appear. So what they look at is whether or not they have confidence that you would appear for either the next immigration hearing, the next procedure in your case, or for removal from Canada if that's the next step in your matter. There's a few things that they can consider under this. I'm not going to go into all of the details, but some of the main ones that do get taken into consideration are your compliance with immigration laws and the Criminal Code of Canada in the past. So that includes any sort of charges, convictions, and any situations with immigration, if you've shown up before and if you've followed your conditions in the past, if you've been on them. And another thing that they can also take into consideration under that is any sort of ties that you have to the community in Canada. So if you have strong ties to the community, they may argue that that shows that you might not be willing to leave Canada. Like I said, there's a number of factors, but those are the two main ones that we see come up fairly often. Another reason why they could have you detained is that they find you a danger to the public. So what this means is that the Minister's Council, who's a representative from CBSA, would argue that because of any past criminal convictions or because of any offenses that have been committed, whether in Canada or abroad, that if you were released, that it would be a danger to the public in Canada. Now this ground, if they do find it exists in your case, does have pretty serious implications for you, which I believe Jessica is going to talk about a bit more later on. The other situation is if they cannot confirm your identity. So if there's some issue with your identity documents, or if there's some conflicting information about who you are, then they can argue that you should be detained until they're able to figure that out. Now these grounds, the burden is on the Minister's Council, again, the representative from CBSA, on a balance of probabilities to show that they apply to you. So basically what that means is that it's on CBSA to show that in your case, one of these grounds exists.
Okay. And so what are your rights? You have some rights when you're detained. You can ask for a lawyer and an interpreter during any part of the immigration, arrest, and detention process. However, in reality, these are not always provided during the arrest part of immigration detention. So it's different than if you're arrested in a criminal context. When you do have your hearing to review your detention, which Malika will talk about next, you will be provided with an interpreter if needed. There's a fairly new program called the Immigration Detention Representation Program, or IDRP, which aims to ensure every person in immigration detention has counsel for their hearing. You have the right to know why you've been arrested by immigration and why they're detaining you. You also have the right to know what evidence immigration is using to justify your detention. That information is in a package called a disclosure package. Immigration must provide you with a copy of these documents, and they must also provide a copy to your lawyer as soon as possible. And that way, your lawyer can advise you of why you're being detained, what information immigration is using to detain you, and how to advocate for your release at your detention review hearing, which I will hand over to Malika.
Thanks, Jessica. So yes, so I'm going to talk a little bit about the hearing and what to expect in that scenario. So basically, after you've been arrested, they're required to get you in front of the Immigration Division, which is the division that decides on whether you should be detained or released, along with some other stuff as well. But they're the ones that are going to be hearing the case before them. So they have to get you there within 48 hours or as soon as possible thereafter. So sometimes if it is a long weekend, there is an extra day or so thrown in there, but typically it is supposed to be within 48 hours. And if they don't, there's an argument that there's been some delay on their part. Now, there's essentially three individuals or three parties in a hearing. So the first party is the member, and they're from the Immigration Division. This is the person who's going to be deciding on whether you're detained or you're released. The second member is called Minister's Council. This is the representative from Canada Border Services Agency, typically, who usually argues for detention in these situations. But they're the representative from the government. The third party is your representative, and that's the person that's arguing on your behalf. And obviously you would be there as well, and an interpreter if an interpreter is needed. As Jessica had mentioned, the IDRP is a program that provides for representation for individuals who do not have their own lawyer and do not have the time to get a lawyer prior to the 48-hour hearing. This individual is, in some cases, they're able to contact you prior to the hearing, but with some institutions, it's been difficult to get a hold of the client before the hearing actually takes place. So what would happen in that case is that at the beginning of the hearing, before any evidence is heard, they would be given a chance to talk to you during the hearing over the phone, which is being taken place right now during COVID, and they can ask you some questions and see if there's a way that they can get you released. I also wanted to mention that if you do have a bonds person, and that's someone who's able to sign for your release saying that they'll supervise you and that they'll put up money to the immigration division to say that, kind of as a bond, essentially, to say that they're supervising you, and if you don't follow the conditions, they would lose that money. So it's a promise to the court, or it can be cash. That person also has to be available for the hearing as well. Now, the first hearing is the 48-hour hearing. If you are detained after that hearing, they must set a second hearing for 7 days after that day. And then after that, if you're detained after the 7-day as well, then the next hearing would have to be after 30 days. And thereafter, it's 30 days as well. You can always ask for an earlier detention review if you have a plan in place to be released. For example, if you were able to find a bonds person, or if your situation has changed and you think that a hearing would be beneficial for you. Right now with COVID, the hearing has been done by telephone, and in some cases, again, depending on the institution, by video. Previously, or prior to COVID, it was done in person at the institution. It's unclear whether it will be going back to person at some point or when that would be happening. So at the hearing, the member is the one who's going to be explaining the procedure to you right at the beginning. Minister's counsel would then get a chance to make their arguments, and then your representative will have a chance to make their arguments. You also have a right to testify at your own hearing. This is something, however, you should discuss with your representative prior to deciding whether to testify or not, because it can depend on the facts of your case and the evidence that you need to present in your specific case. I'll turn it to Jessica to talk a little bit more about the evidence.
Okay. So the evidence that you can present for your case is kind of guided by Section 248 factors. And these are, so first, immigration must make out the grounds of your detention. And if immigration has made out the grounds of your detention, then the board member considers a number of factors when deciding to release you. And those factors are set out in the immigration regulations, Section 248. So I'll just go through those and then sort of provide examples of evidence that you can present. So the first factor, the board will consider the reason for your detention. For example, if immigration is arguing that you're a flight risk, then you'll want to present evidence that you're not. This can include, for example, your attempts to continue to have valid immigration status in Canada. Next, the board member will consider the amount of time you've already spent in detention. So as Malika said, you get detention reviews during set amount of time. So within the first 48 hours, 7 days, then 30 days. So the board member will consider how long you've been in immigration detention. I personally argue that any deprivation of liberty is lengthy because it is. The board member will consider your future length of detention. So for example, if you're being detained because immigration does not believe that you'll show up to the airport for your deportation, but you don't have a valid passport and you need one to get on the plane, then you're likely to have a lengthy future detention. So evidence of that would also be important. At your hearing, the board member will consider any delays or lack of diligence on the part of the detainee's part or immigration's part. So for example, if you've been diligent in keeping your passport up to date, then you can provide evidence of that to show that you've not caused delays. If immigration waited several years to act on an immigration proceeding for you, then that could be a delay on their part. It's all very case specific. Now, the next thing that's considered is pretty important, and it is alternatives to detention. So the purpose of an alternative to detention is to offset concerns about the reason why you're in detention. So if immigration has made out the reason for your detention, and I'll use flight risk again, then you'll need to show that you have an alternative to detention that offsets that, quote unquote, flight risk. This can include a bondsperson, like Malika mentioned previously. And a bondsperson is similar to a surety. It's a person who should know you, know about your immigration situation, and be able to supervise you. Often the expectation is that you live with your bondsperson, and they'll most likely be expected to post a bond. If you don't have a bondsperson, there are other professional supervisory programs. They'll find you a place to live, often in a shelter. If an issue with drugs or alcohol somehow factored into your arrest and detention, you might be expected to show that you'll be enrolled in a treatment program if you're released. The same goes for if you have a mental health condition that may have factored into things. You'll need to show that you'll be receiving treatment when you're released. And I'll say that a lot of this is a huge obstacle for people in detention. How does one enroll in a drug treatment program when they're in jail? Also, compulsory addiction programs is not necessarily an effective way to address addiction. It's one of the many areas where I personally question whether immigration detention is purely administrative, because making somebody's a liberty hinge on whether or not they're enrolled in a treatment program is, I think, unfair, and I'll just leave it at that. Also, immigration detention then can become a way of institutionalizing folks who are not Canadian citizens and who live with a combination of things such as poverty, trauma, addiction, and mental health conditions. Another factor that's considered is the best interests of a child who's directly impacted by your detention. So for example, if you're a primary caregiver for a child under the age of 18, you should provide evidence of that. And then the last thing that's considered are the conditions of detention. And this can be really broad. One thing that's been relevant to the work that we've been doing recently is COVID-19. There have been numerous outbreaks in jails that have impacted immigration detainees. And so that is evidence that can be used to argue for release. And passing it over to Malika to talk about release.
Thank you. So this topic, it overlaps a lot with what Jessica was just talking about. So basically, if they order your release, what they do is they give you a release order, and typically it has a number of conditions that you're required to follow while you're released into the public. So the conditions range, and it will depend on your individual case and what the ground they found existed. So for example, Jessica had mentioned flight risk. One of the conditions that they will likely impose in those cases is reporting to CBSA. Now, the duration or the length of, the amount of times you have to report, so whether that's once every 2 weeks, once every month, once every week, would depend on how much of a flight risk they find you. So the conditions are really tailored for each individual situation and the findings that were made in the hearing. I did want to mention a few that are quite common and that are very important in this context. So one of them is that if you have no status in Canada and if you're not entitled to be, or if you're not entitled to be working, there is a condition that they can impose that says that you're not authorized to work or study unless permitted by the Act. So what that means is that there's an actual condition on your release order that unless you've been given permission in the form of a work permit or a study permit or something along those lines that allows you to work while you're in Canada, you are not allowed to. And if you do end up working, you would be in violation of your release order. Now, being in violation of your release order, if they do find that you have breached one of the conditions, they could come and arrest you again, and they could have another detention hearing where that would be taken into consideration. Jessica had mentioned as well that there may be a condition on living with your bondsperson. That's typically so that CBSA knows where to find you in case when they send notices about your hearing or any sort of removal proceedings. It's also for a supervisory purpose in the sense of having someone there who's with you majority of the day to make sure that you're following all the conditions. A couple of other conditions, like Jessica had mentioned, are the treatment programs that they might require you to attend to. They might also, if you're a danger to the public, they might ask that you be put on a curfew or on house arrest. So there's actually a number of different conditions that they could impose. And again, that just depends on the facts of the case and what the member thinks is appropriate in your circumstance. It is supposed to be conditions imposed that are necessary, and they are supposed to be the minimum of what is required to offset any concerns that were raised during the hearing. Jessica, do you have anything else to add to that one?
No.
Okay. So I think that's the end of what we had prepared in terms of questions to give you a broader outline of how these hearings work and what the process is and what type of evidence to present. Sarah, thank you for joining us. I don't know if you have any questions for us from the members that are watching.
I do. So I will start off with this question. And feel free to jump in, whoever wants to answer it. So I am a SOP worker, a seasonal agriculture worker, and my employer is abusive. And I spoke to a consultant, and they said that I can go work for another employer. What are your thoughts?
So I guess I'll start and then Jessica jump in with anything else. So with SOP workers, it's typically, and correct me if I'm wrong, but it's a closed work permit where it's tied to one employer. So because your work permit only requires you to work for that employer that's listed on the permit, you are not actually authorized to work for anyone else. If you are being abused, however, what the consultant should have offered and what you can go and see a lawyer about is applying for a vulnerable work permit. And what that does is it allows you to get an open work permit for a specified amount of time so that you can safely leave your employer and find another job somewhere else. So that open work permit is not actually tied to a specific employer. It lets you work for anyone except very few employers that do not meet the act. So in this case, that's what I would suggest that you would do, because if you did work for another employer unopposed work permit, you would be in violation of that.
Jessica, do you have any thoughts?
No, I don't have anything to add to that.
Okay. I'm just wondering, as a follow-up, if this person does decide to leave, would they have status, or is there any danger of being detained by the CBSA?
Jessica, I'll let you take that one.
Well, I mean, they would, I guess, as soon as their employment is terminated, then their status would become precarious. And, you know, there's, and then as a result, yes, there could be a possibility of detention.
Okay. All right, thank you. I have another question here. If I'm detained by immigration, is there any circumstances where someone would be released without a bond? Malika, go ahead.
Sure. So there are circumstances where you can be released without a bond. So actually, once you're arrested, CBSA will look over the case, and if they think that they can release you on conditions without having to have a hearing, then they can do that. Okay, so it's not that all cases go to a hearing once you're arrested. Once it does go to a hearing, there's still an opportunity for you to be released on conditions without a bonds person. So what it's called is release on your own recognizance. Mm-hmm. So that's them saying that, look, we're going to release you and you're required to follow by these conditions.
And does the bond person need to be a Canadian citizen? Jessica?
No, they don't have to.
Okay.
Sorry. The only thing I'd add, I think me and Jessica had just talked about this yesterday, and it had actually come up in my case. So I'd asked around to people who had been doing this for a while. So they don't have to be a Canadian citizen, but there's the amount of bond that's placed. Mm-hmm. So just say, for example, it's like $1,000 for you to be released. If they're not a Canadian citizen, then, and I believe if they're not a permanent resident, so if they're just a foreign national, then that money would have to be paid in cash. So they're not allowed to just make a promise to the court that they would pay it. They would actually have to do a cash deposit.
Okay. Now, can a person still be deported if they were born in Canada?
That's a good question. Technically, they would not be deported or they couldn't be because they're a Canadian citizen. However, what ends up happening is oftentimes folks who are not Canadian citizens have children born in Canada. And so their children are Canadian citizens. And then immigration proceeds to remove or deport the parents. Mm-hmm. And then the parents have, I mean, it's a choice, but it's one of those choices that are not really choices because, you know, you're stuck with two alternatives of either, you know, bringing your child with you, which, you know, sometimes can either make their lives, you know, hard or at risk, but they get to stay with their parents, or leaving the child in Canada without their parents. So a Canadian citizen can't be deported, but there are circumstances where deportation does impact a Canadian citizen such that they do leave with a person that's being deported.
Malika, do you have anything to add?
No, I think Jessica covered that pretty well.
Actually, with that question, I was wondering, when it comes to the best interest of the child, does the child have to be a Canadian citizen? Is that something that they consider when it comes to deportation?
No, the best interests of the child is broadly defined, and I'll let Malika answer the rest because I jumped in. I think it was your turn.
No, well, I was going to let you have that one. But no, they don't have to be a Canadian citizen. So it's someone under the age of 18. So if you have a child at home that you're a primary caregiver, or if you're the individual who's financially supporting the family, and detention would have an impact because you would lose income, and that would directly impact the child, just for example, then that could be argued at the hearing.
Mm-hmm.
And again, this is for detention review hearings. I just wanted to.
Right, okay. I was going to ask here, so you said that a person is entitled to a lawyer and an interpreter. Say if the person does not have either of those, do the proceedings continue, or they stayed, or they stop, just so the person can get a lawyer and an interpreter for the proceeding? Jessica.
Oh, okay. So for the hearing, if a person asks for a lawyer and an interpreter, the hearing won't proceed until the person has counsel and an interpreter. In terms of the arrest, so during the arrest process, the person who's being arrested will be asked questions by immigration, and they might ask for a lawyer, but it won't trigger this immigration to stop asking questions in the same way that it should trigger that in a criminal proceeding or in a criminal context. So the rights and the procedural protections are much less.
Right, yes. Less than, say, in the criminal context?
Yeah.
Sorry, I'm looking at my phone because I'm looking at questions. I have another one here. Can I work if I'm released after being detained for an immigration infraction?
So again, that would depend on your status in Canada. Like I mentioned, one of the release conditions that they do put on if you're not allowed to work is that you are not allowed to work unless you're granted, unless you apply for a work permit and you're granted that. So if you do continue to work even though you don't have permission to do that, then you could be in breach of your conditions. And again, that's if that condition is put on. Yeah, Jessica, I'll let you continue or hop on after that.
Yeah, just like Malika said, a lot of it is dependent on the release conditions and your status.
With that, what if the person has a tourist visa? So they have status, but maybe with the visa, tourist visa, perhaps they may not have legal status to work. Would that affect their detention, or would that have any impact on them when it comes to immigration?
Yes, so if they were detained in that case and and CBSA was aware that they were working without authorization, that's definitely something that the member would take into consideration or could take into consideration, because technically it would be argued then that you haven't been in compliance with immigration laws. And that's, like I said, a factor with the unlikely to appear is your compliance with immigration laws and showing that you've complied in the past. So it would definitely have an impact in that sense. It's up to the member at the end of the day as to how much impact and what the evidence is exactly, but it is something that can be taken into consideration. One of the other things I meant to mention was just that sometimes what they consider in a detention hearing is that if they do release you and you're not authorized to work, how do you plan to support yourself while you're in the public? So that sometimes is raised as a concern to say, okay, like, how would you do it without resorting to having to work and then not being in compliance with the immigration laws? So there's a number of different ways that it could be considered at the hearing.
Jessica, feel free to jump in.
No, I think.
Okay, I just wanted to give you a chance, but I do have another question here. Say when it comes to, you mentioned there were terms or conditions for your release. Say if a person is being detained because they're deemed as a danger to the public, and you mentioned criminal record, would they consider, your compliance to detention as one of the issues with like being a danger to the public? Sorry, I can rephrase that. I said that in a very wordy way.
No, that's okay. Can you maybe explain a little bit more about complying with detention? So, like, do you mean like somebody's behavior while they're in detention?
Maybe they were detained in the past because
Okay.
they did not comply with, rules in the past. Would that also be in their criminal record, or would that be separate?
So, for immigration detention, somebody's criminal history, including charges, it can be disclosed and can be used as evidence that immigration relies on to argue for somebody's continued detention. So if they had been in detention in the past, that would just support immigration's arguments that this person has a history of not following the rules. And so then we should not release this person because they're most likely gonna continue to not follow the rules. And in a danger context, the bar is much higher to get somebody released. So you have to show that your alternative to detention is going to effectively completely offset any danger concerns. So it's much more it's much more difficult to argue for release. The standard's higher.
Okay. And how long do things, say if you do have a criminal record, but you did something 20 years ago, is that still relevant if you're detained, or if they're trying to release you more recently?
So yes, everything's relevant. Everything's on the table in these matters. And then the lawyer would argue, the lawyer who's representing the person who's detained would then argue about relevance. And they would say, well, so for example, what I do when I am representing somebody where danger to the public is on the table, I will try to contextualize their criminal history. So for example, if their last conviction was 20 years ago, then I would say, well, look, this person, yes, they have been convicted of this offense, but it was 20 years ago. And then this person has, 20 years of, not having any convictions for violent offenses.
Okay. Does your criminal record affect any other applications that you might make to get status in Canada? Malika.
Sorry, my eyes were going wide and I was nodding yes. It's a very broad, it does. There's criminal inadmissibility is a large part of, well, a lot of what I do personally, because I've had a past as a criminal lawyer as well. So it's very context and case specific in terms of what impact it would have. That depends on the application that's being made, the individual status, when the conviction happened, what's happened since then. So there's a number of questions that you have to look at in that situation. There's ways to definitely get around criminality, but it is very case specific and context driven.
Okay. Can a person be detained indefinitely? So more than 20 years? Jessica.
Technically, yes, a person, their detention is reviewed, after they have their 48-hour hearing and their 7-day hearing. They're entitled to a review every 30 days. So yes, there are some very lengthy detentions that happen because those reviews, they rely on the previous findings. Even though each review is supposed to be new, they can still rely on previous findings. And if there's no change in evidence and, a number of other circumstances, a person, yes, can be detained for years at a time.
And Malika, if somebody is actually in danger of potentially getting detained because of, perhaps they don't have status in Canada, what can they do practically to prepare themselves in case something like that happens?
I would say having, if they do have people who could potentially be bondspersons, talking to them, having their contact information handy, because that would be very helpful and that would help speed along the process of getting them released if that is available to them. Otherwise, I don't know, Jessica, do you have any other ideas of what they could do prior to that?
No, nothing off the top of my head. I also got distracted a little bit for that question because my cat wanted up. Sorry.
Let's be part of this conversation.
Yeah, he's just been around my feet for a while now, so it's all right.
You mentioned that there's only one detention facility in Ontario, and then there are people who get detained in prison. Is there any things that they should think about if there is a danger of being detained in the future and they might end up in a prison setting? Is there something they can do to prepare for that?
Well, that's a tough question. I mean, how do you prepare for incarceration? I feel like there's just, and I've had my own personal experiences with being detained. I don't think that there's really any way you can prepare for something like that. I think, figuring out counsel as soon as possible is important. But really, I just don't know how else a person can prepare for that. And oftentimes it's just a complete shock and surprise that when somebody finds themselves in that situation, and it's sort of like a nightmare becoming reality.
I think there was one other question with that. When it comes to, again, going back to the same question, is there, and you mentioned there's you can assign or have a bonds person potentially. that can help you. Do the CBSA officers tell like provide any kind of information when they're arresting an individual or they're about to be detained? I don't know. We have that in the context of criminal arrest, but is there something similar in the context of immigration detention?
Jessica, I don't know if you know of anything. I don't really.
Yeah, I've had a couple cases where actually I saw in the disclosure that they had canvassed with the person, a potential bonds person, trying to get their release so that it didn't have to go to a hearing. So that is something they can do.
That's true. And then I would also say, to add, no fixed address is a big problem. So what that means is that if someone says, oh, like I don't really have a place where I live, or I'm kind of moving between places, then that raises a bit of red flags to CBSA in terms of being able to locate them and for some stability. So if that individual can arrange for somewhere that they can live and that they know they can reside, then that would be helpful as well. And just to let CBSA know that, hey, like I do have an address that you can get a hold of me at, that might assist.
When it comes to representation, does it have to be a lawyer? Jessica.
No, it doesn't have to be a lawyer.
Would you recommend a lawyer?
I think it's good to have a lawyer. There's a lot of consultants and paralegals that do good work as well, especially paralegals. In fact, at the Refugee Law Office, it's a lot of paralegals that do the detention review work, and they do a fantastic job.
Okay. Are there any reasons why my proceedings might be delayed? Beside, if I have representation and an interpreter, can I get is there a detention review, within that set amount of time, or can there be any delays in the process? Malika, if you want to try this question.
Sure, I'll start, and then if Jessica has any other experiences, I'll get her to jump in. But there's been institutional delays. So depending on where the individual is being detained, there have been issues with connecting to the phone or to video. In some cases, if there's security problems, then they can only do like one hearing at a time. So there's been some delays. But it's pretty strict with the division as to when they're supposed to be doing these detention reviews. So in my experience, they do usually try and make it happen within a very short period of time after.
Okay. Jessica, do you have anything to add?
No, just that they are required by law to review your detention within a certain amount of time. So any kind of delay is a very serious breach of your charter rights. And so delays can happen, but it's very serious when they happen.
Okay. I have actually a really good question here. If I have an immigration infraction, can I get a new work permit? Malika?
Jessica, I don't know if you're a bit more comfortable taking this one because I haven't done as much work with work permits. I mean, I think it's case specific as well. Like it depends on what the infraction is and how long it occurred for, if they had gone to a person to represent them and they had made a mistake, or if it was on them and it had been like years versus weeks or stuff like that. So I think it's very hard to give a general answer to that. But Jessica, I don't know if you have any other tips or suggestions.
Yeah, I would agree that it's very case specific. And I think that the example that Malika gave when we started the Q&A, like, so for example, a lot of folks who are on closed work permits and who experience abuse by their employers, for example, then they might leave their employer and work without authorization, but like then they could still also apply for an open work permit for vulnerable workers. So it's very, very fact specific and very case specific.
When you're detained, what kind of resources do you have when it comes to self-care? Oh, okay.
It's tough right now because of COVID, I think, especially.
Yeah.
I know that the Immigration Holding Center, which is like the detention center, is supposed to be a little bit better, but I think with COVID, it's just been really tough. Like I've heard from a lot of clients who haven't been able to shower for a number of days, and like there's just been a lot of issues with that. I don't know if this also existed pre-COVID, as I've been doing detention reviews more recently and just during the pandemic. Yeah, Jessica, I don't know if you have any other experience with that, but I've definitely heard of a few situations like that.
Yeah, I mean, I don't know like how self-care works when your liberty has been taken from you.
Yeah.
Because like the state has then taken control of like your autonomy. And then with COVID, especially, the conditions of detention are just, it's made a bad situation worse. So there's lockdowns, people are, kept in their cells and maybe just given 1 hour a day to be outside of their cells. It's hard to get medical attention. It's been really, really bad. I think that, really just trying to get released is the only way to, I don't know. Yeah, it's a really hard experience to go through. Like it's
traumatizing.
It is.
Yeah. So are you entitled to any, you mentioned that it's harder to get medical care, but are you entitled to it when you are detained?
Yeah, you are entitled to it. Whether or not that's actually something that's realized is a different story. There could be like a few reasons. Like there might be, less sort of, and maybe the guards might not be taking the medical requests on a regular basis because of lockdown and COVID prevention measures. So it's just really hard. That's why it's really important to have an advocate on the outside who's advocating for you and making sure that you're getting medical attention and whatnot. And yeah, it's a difficult experience.
So are new people getting detained and deported at this time? I know there are already people who are detained, but are they also getting more people to be detained? Malika, let's start with you.
We're both nodding yes. Yes, to me, it feels like there's been a bit of an influx in the last little bit, like compared to during earlier in the pandemic. But yes, removals are happening again. There are some delays due to COVID in terms of getting flights and travel documents and stuff like that. But it has resumed, and arrests have resumed, and yeah, there's been a number of detention hearings lately.
Do I have to pay my bonds person who's posting a bond for me? Jessica?
No. The bonds person is not allowed to take money from the person who's detained for the purpose of posting the bond.
Do you know of any instances where that might have been an issue, at least in the background?
It's possible that that's actually what ends up happening, but that's not allowed.
Okay. And so if I have been deported, can I return to Canada? Malika.
Again, very fact specific and very case specific. It depends on what type of removal order you had. Like the types of, like if you can apply for, just say if there's a sponsorship and an H&C application, like it's just very fact specific, I feel, that it's hard to say, like it's not a no, but it's also not a yes necessarily. It depends on your certain circumstance. And like the reason for why you were deported as well. Jessica, anything to add to that?
No.
Well, Jessica, do you have any last minute advice? We have 1 minute left. Sorry to put you on the spot. And Malika, jump in if you wish.
I hope we covered as much as we could in this hour. I mean, if there are any further questions, happy to answer those if they come through Facebook or something like that, and we can try and get an answer out if possible. But yeah, I think that's everything on my part.
Well, thank you so much for all your insight and knowledge. I think I learned something too, so thank you.
You're welcome. Thanks for hosting.